Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, tomorrow is a big day before the United States Supreme Court, especially if you cherish the inalienable right of making personally made firearms. That's right, because the matter of Garland v. VanDerStock gets before the 9-judge panel tomorrow of the Supreme Court. We got oral arguments set for tomorrow. Now, we're not going to get a ruling tomorrow, obviously. A ruling will come several months later, but we did want you to kind of geek out again, get yourself familiarized with this case, because this case is huge, has massive implications. So today, let's spend a few minutes, let's refamiliarize ourselves with it, and let's talk about the future of homemade firearms rests with the Supreme Court tomorrow. What do you got there, man?
TacPack.
Oh, sweet, a TacPack? Nice.
Oh, what's a TacPack?
That's the new sponsor of the channel.
So what's in a TacPack?
Oh, what's in a TacPack? Well, here's the best thing. It is a monthly subscription of all sorts of tactical gear. And I mean, they got a lot of really cool stuff. The best part about it is that they actually have two separate subscription models. So they got their TacPack Standard, which ships at $59.95 a month. Best thing about that is it really has a value of about somewhere between $90 and $120. And then they got the TacPack Plus. Now that ships at $139.95 a month, but, oh, check this out. They actually have a value of somewhere between $240 and $300.
Wow, that's pretty cool.
Yeah, it's super cool, and here's the coolest part yet, because if you sign up right now for the TacPack Plus and you use the promo code GunLawYT, you're going to get an extra $60 everyday carry kit, which means that your initial investment for less than $140, you're going to be ended up getting over $300 worth of tactical gear. Listen, look at some of the cool things you're going to get if you subscribe to TacPack today. So get down there, check out the link below, make sure you use the promo code GunLawYT. Check out TacPack. Okay, America, here's what we're talking about today. We are talking about the case of Garland v. VanDerStock, formerly known as VanDerStock v. Garland. This is a challenge to ATF's rule on unfinished frames and receivers and part kits, or essentially when the ATF suddenly thought that they had the statutory authority to regulate chunks of aluminum as well. As we know, the Fifth Circuit has thrown this out. The United States government appealed to the United States Supreme Court. Supreme Court has accepted review, and away we go. Now, I went back and I took a look at the petitions for certiorari, as well as a bunch of amicus briefs. What we're going to familiarize ourselves with today is the amicus brief that was written by 26 separate attorneys general around the United States, because this brief, I think, does a really good job of kind of taking us down memory lane as to what the ATF has been up to and why the Fifth Circuit's ruling, throwing this rule out, needs to be upheld. The issues presented by these attorneys generals include: 1, whether a weapon part kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive is a firearm regulated by the Gun Control Act of 1968. 2, whether a partially complete, disassembled, or non-functional frame or receiver that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver is a frame or receiver regulated by the Act. And that certainly is the issues presented, but what the attorneys general point out here is, listen, this administrative agency, the ATF, has a long history of just operating way outside the statutory confines of what they have been delegated. They run roughshod over constitutional rights all the time. They run roughshod over statutory interpretation all the time. And this is just yet another example. As the AGs point out, ATF has a history of pushing the limits, and it's doing so again. Even though these statutes have remained essentially static for decades, ATF's role in executing them has somehow grown larger day by day. In ATF's view, it must create new definitions that are general enough to account for changes in society. Not so. ATF misunderstands its own job, and this misconception is statutorily unjustified and constitutionally impermissible. Time and time again, ATF has ventured off into the regulatory wilderness, abandoning the only statutes that give it life in the first instance. In other instances, it has ignored its obligations under the APA to bypass legitimate objections to its regulatory misadventures. And so the AGs wisely point out, ATF's frame final rule is more of the same. But to understand just why ATF's regulatory work can't really be trusted, it helps to travel through the rabbit hole of its fickle regulatory scheme. It's a dizzying ride. And then, of course, the Attorneys General takes us on this wonderful little stroll down memory lane to talk about all of the things that ATF has done and how did they ultimately get resolved once the courts got involved. Let us start with bump stocks. Oh, wait, we already know how bump stocks were resolved. The Supreme Court had to do that itself, which, of course, led to the AGs pointing out, ultimately, ATF had impermissibly abandoned the text of the statute it claimed to execute. Oh, but they didn't stop there. Do you guys all remember firearms with attached stabilizing braces, or what we call the pistol brace rule around here? We probably covered no ATF rulemaking order more than that ridiculous pistol brace rule. How did that work out for the ATF? Well, as the Attorneys General also point out, yet the brace final rule was a building with no foundation, as the statutory text rejects ATF's interpretation. So once more, ATF showed itself an untrustworthy steward of the statutes. Oh, but hey, they didn't stop there. Let us remember what happened once the Bipartisan Safer Communities Act was passed and what the ATF decided to do in interpreting who's engaged in the business of being an FFL. And even though that litigation is ongoing, it too is traveling the same path of success, or lack thereof, that the pistol brace rule and the rule on frames and receivers did as well. And of course, the AGs have to point out, ATF took the Bipartisan Safer Community Act as an invitation to turn the system upside down. Galvanized by this minor statutory adjustment, it proposed a new rule to clarify the meaning of the terms Congress just defined. But once more, ATF's rule has a problem, namely its inconsistency with the statute meant to justify it. And that is a massive problem when it comes to the ATF. They're constantly trying to define terms in statutes that need no further definition. Translation, what they're trying to do is redefine it so that then they can actually amend the statute itself. An act should be reserved exclusively for Congress. But that's not the only problem here for ATF. Now, there's another one, and the AGs correctly point this out as well. Aside from the textual conflicts between the Gun Control Act and the dealer final rule, there's one more foundational issue. The Gun Control Act does not give ATF authority to define terms in the first instance. Yeah, that's right. No, the ATF should not be defining terms. That actually should be left for the role of the court if the legislature fails to do it adequately. And as we now know from the Loper-Bright case, we're not really too keen on giving administrative agencies the ability to interpret their own rules. It's a little bit too much like the fox guarding the hen house, and what the Supreme Court had ruled is that was a violation of the APA because no administrative agency has been given authority to interpret the laws that Congress has passed. Which again, of course, brings us now full circle to this issue as it relates to unfinished frames and receivers. All that brings us to the dispute before the court now. In trying to squeeze weapon part kits within the meaning of the Gun Control Act's definition of firearm, ATF is once more trying to stretch its enabling statutes too far. In every instance outlined above, the law hasn't changed, only the agency's interpretation of it. And with each broad brush expansion of liability, a host of constitutional and other issues arise, be it inconsistency with the major questions doctrine, violations of Second Amendment rights, or new due process concerns. So too here. ATF's rule just isn't grounded in the statute, as respondents well explain. But there's more here, and there's more that you need to be aware of as to the importance of this case. But here, ATF is also playing fast and loose with its responsibilities under the APA, which only further compounds the problem. And again, there's another problem, which is this logical outgrowth problem. That is essentially you publish a rule, everyone comments on it, and then you radically change the rule such that the public never had the ability to comment on it. And that's exactly what happened with the pistol brace rule, and that's exactly why everyone needs to participate in the comment section. But as the AGs point out, so this case presents a logical outgrowth problem, a situation in which the agency significantly amended the rule between the proposed rule and final versions, making it impossible for people to comment on the rule during the comment period. Okay, now if you start geeking out on all of the people who are supporting the United States petition to have the Fifth Circuit ruling overturned, you will realize that they don't really cite to the Constitution, they don't really cite to statutory text, they don't really cite to common sense or anything like that. But what they do cite to is the parade of horror stories that have been perpetrated as it relates to unserialized firearms. And of course, the AGs respond to it in kind like this. Left with little in the way of textual support, many of the ATF's amici argue that this court should depart from the statute's plain meaning because excluding ghost guns from the Gun Control Act scope would purportedly have dire consequences. That's right, we should just ignore the plain language of the statute to reach a policy goal. But as the AGs wisely point out, in the end, no matter how wise ATF's rule or how weighty petitioners' policy concerns may be, the final rule exceeds ATF's statutory authority, and that should be the end of the matter. Now listen, mainstream media is going to portray this like this is all about putting illegal ghost guns back onto the streets, these weapons of war that law enforcement officers cannot trace, we cannot solve crimes. This is all about just arming America and making America more dangerous from this renegade runaway Supreme Court. Now that is what the mainstream media will be saying. But the AGs correctly point out that this is about something much bigger than that. It's about the very structure of how our country is supposed to run. Policy concerns cannot trump the best interpretation of statutory text. In the face of unsuccessful legislative efforts, judges may not rewrite the law simply because their policy views update the law merely because they think that Congress does not have the votes or fortitude or predictively amend the law. And that is exactly what the ATF has done in this instance and what they have done in all previous instances. This is a huge case that will be up for oral arguments. We're going to link up how you can listen to the oral arguments tomorrow before the United States Supreme Court. The case, once again, is Garland v. VanDerStock. Congratulations to all the plaintiffs and amicus party to make this possible. We will probably do a video in the next couple days kind of wrapping up and trying to read the tea leaves based upon where oral arguments went. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. But if you don't, that's okay. That information is down in the description box. If you got an idea for a video we should be doing around here, go ahead and click on that link. Let us know all about it. It's probably better than any idea we'll come up with. If you just want to be part of our monthly newsletter, the ability to subscribe to all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.